Hi, welcome back to the AITX Community Podcast. I'm your host, Jake O'Shea. This is the show where we dive deep with some of the most interesting AI engineers, entrepreneurs, researchers, investors, and operators across the state of Texas. Our mission is to pull back the curtain on what's really going on in AI in a way that's accessible and engaging to anyone that has a stake in the future of this technology. We've specifically decided to focus on Texas because we believe that the Texas engineering community is seriously underrated. People in Texas are building incredible products and solving complex technical challenges, and our hope is that this podcast helps share some of those stories with the rest of the world. This week's episode is a little different than our usual focus on engineers and entrepreneurs. Today's podcast features Kevin Frazier. Kevin's a lawyer and policy expert, the senior editor at the Lawfare Institute, and the inaugural AI Innovation and Law Fellow at the University of Texas School of Law. AI legislation and policy is rapidly evolving. And as AI begins reshaping industries and culture with vigor, our elected representatives are sometimes struggling to keep up. If elected officials do nothing, we risk AI reshaping society in negative and unpredictable ways. On the other hand, if we overregulate this technology and industry, we risk losing our leadership position in the field while competitors take over and actually hamstringing our own economic growth. It's a really nuanced discussion around AI policy and has lots of different stakeholders. But no matter what your position, it's important to be informed of what's actually happening today and what's being proposed for in the future. And that's why I'm so excited to share this conversation with Kevin. Kevin's incredibly knowledgeable about the underlying technology of AI, as well as its political implications and the current state of policy proposals and implementation. He's a strong advocate for AI integration, and in his role at the UT Law School, he's actively training the next generation of lawyers and legal talent on how to use AI and integrate it into their workflows. Kevin's perspective is unique and very important, and so I'm excited to share it with you all. Now, without further ado, please enjoy this deep dive with Kevin Frazier. All right, we're live. Kevin Frazier, thanks for being here today.
Thanks for having me, Jake. Always a pleasure to chat AI with you in particular.
Absolutely. Well, let's dive in. I think to start, would love to give any listeners a little bit of context about yourself. So tell us kind of your personal story, like where'd you grow up, what led to a career in law, and then we can dive a little bit into how that's now intertwined with AI.
Yeah, so I like to say that I grew up watching too much of The West Wing. And so for folks who haven't seen The West Wing, you should. I don't know what rock you've been living under, but invite me next time because living under a rock sounds kind of nice some days. But The West Wing is all about politics kind of going right and idealistic folks finding ways to compromise and solve problems. And so was really interested in politics from an early age. So when I graduated from the University of Oregon, I went and worked for our governor as her body person. So was the dude, if folks have seen Veep, I was her Gary, just carrying her bag around and making sure she had her talking points and Cliff Bars. And that was an awesome experience and gave me a chance to see how the sausage really does get made at the state level. And let's just say it wasn't the West Wing. And I realized that state governments in particular have a really tough time recruiting experts, retaining experts, just paying for experts, and also have difficulty building relationships with tech companies in particular. So I thought, all right, this was a really fascinating experience, logged a lot of miles going around Oregon, where I'm from. And then I thought, okay, I need to go see the exact opposite. I've been living my little West Wing fantasy for long enough. Let's go see the opposite end of the spectrum. So I went and worked for big tech. I went and worked for Google on their legal investigation support team, and that's the team that receives all of the requests for user data from law enforcement. So, everything from the FBI saying, hey, we want to see Jake's emails from January 2021 to January 2025. And we'd say, go fish, be a little bit more specific, so on and so forth. But that gave me a chance to wake up every single morning and get, as a Google employee, you get this newsletter that's just summarizing what the company does, as I presume most companies do. But for Google, for big tech generally, it's here's what we did in Kenya. Here's what we're planning to do in Taiwan. And these are the new relationships we're building all over the world. And you realize that with just a click of the button, big tech can change billions of lives. And so that really teed me up to think, how can I serve as a translator between the state government and government more generally, which I really want to work and believe in terms of serving public policy issues, in terms of meeting public needs, and help them harness all the great things about big tech and tech generally. And so that set me off on a path of working for various tech companies. I worked for Verily, I worked for Cloudflare, and getting a JD from Berkeley and a Master's of Public Administration from the Kennedy School. And then it just became a task of finding how I could do that translation work I talked about at scale and to a greater effect. So I had a fellowship at a group called the Institute for Law and AI, which focuses on law and AI, and did some research with them and helped drafting legislation and analyzing legislation right after the introduction of ChatGPT. Got hooked on AI in particular and thought, well, this might be a thing. How do I go even deeper into this? Ended up teaching at a school in South Florida before I found my way here to Austin at the University of Texas School of Law, where I'm the AI Innovation and Law Fellow, an inaugural program that's going to really make sure that every student that comes to Austin is ready to help build the future.
Awesome. I want to dive into definitely the work that you're doing with UT, but maybe before that, one, also love The West Wing. Great show.
Sorkin.
Sorkin.
He's just
Sorkin. He's a legend.
He's got something figured out. Although, yeah, I want to go back and just rewatch all of his stuff, but my wife isn't the biggest Sorkin person, so it's going to be a workout show, I guess.
Yeah, they pioneered the single shots where you're kind of walking through the hallways of the West Wing and it's all one shot, but people are coming in and out talking about different topics.
Mm-hmm.
It's something I always appreciate when I see it in other shows. So you kind of came out of school and started working at kind of the intersection of policy and deep tech after that experience with the state government. Obviously now the interaction between kind of policy and big tech is really focused on AI. But when you were at Google and some of these other tech companies, like what are the normal or standard ways, I guess, that technology companies have to interface with policy organizations or the government? Like what were some of the projects that you were focused on? You mentioned something at Google, but just curious to dig in a little bit more.
Yeah. So with respect to Google, I'd say the biggest issues, and same goes for Verily. Verily is a Alphabet company, so a sister to Google in some ways, or a brother, depending on who you ask, I guess. The biggest issues there, I'd say, were privacy, at least in my realm, and just thinking through, in particular, how do oftentimes really outdated laws, I mean, the Privacy Act that governs a lot of how the federal government uses data, for example, that Privacy Act is from 1974. The Stored Communications Act, which I had to interpret on the legal investigation support team, that's another law that's decades old. And so a lot of the work for big tech and tech generally was trying to work with regulators, law enforcement, to just update these laws or try to force them into the 21st century. And that's not easy because oftentimes it meant walking through the technical aspects of whatever Google was doing, whatever Verily was doing, whatever Cloudflare was doing, and helping lawmakers and regulators understand the nuances of this technology. As you can imagine, a bunch of lawyers trying to speak engineer doesn't always work well. And so that can lead to comical emails, comical exchanges. But as funny as that is, there's often very real issues at stake. I think that one of the things that stands out from my time at Google was, in addition to receiving requests from law enforcement, we would just receive requests from users around the world just seeking data for either their own data or data from a loved one, for example. So one particularly tragic story, there were parents trying to access their son's photos. Their son had passed away and had all of these Google photos associated with their Gmail account. But the parents didn't have their son's password, understandably. Like any good teen, I'm sure he didn't disclose that. But that meant that they had to, pursuant to the relevant law, try to get a court order to access their own son's photos, their deceased son's photos. That's crazy when you just think about Do we want these people to be able to see the memories of their child? Of course, everyone agrees with that. But we didn't have these sorts of reliance on internet systems, on technology generally, when these laws were written. And so it can lead to really frustrating experiences. And that's sort of been a motivating story of mine of thinking about how consequential access to technology is and how reliant we are on technology. When you have bad laws or when you have outdated laws, that's not just like something to write a law review article on or write a really compelling essay about or an op-ed. This is impacting people's lives when we don't write good policy. And so it's those sorts of stories that animate me.
Would you say that that relationship between like a tech company and policymakers or the government, is that generally more collaborative or more combative? Because I can imagine like in this instance that you shared, probably everyone at Google was like, yeah, let's figure out a way to give people access to their kids' photos, right? But in a lot of other situations, you guys need to kind of be careful about what you share and what you don't share, because you're also in many ways kind of covering Google and making sure that they're following by the rules. So like, how do those dynamics between kind of a technology company and a government, how have you seen those play out?
I think it's highly contextual, right? As you were alluding to. If you have, some law enforcement agent who just insists that they need to see all of your emails from the past 4 years using a keyword search of right? Like, no, Google's going to say, hey, look, that's way too expansive. You don't need to see all of those emails. Try again. Okay, fine. Keyword search A and right? If you're going to have that sort of poor negotiating partner around these sorts of requests, there's going to be some anger and some tension that results.
Some combativeness.
Yeah. But I think that what I want to hit on more generally is that, again, I do think, just to be explicit, I think there's a really important role for regulation to play in governing tech and in shaping the direction of tech. I just really, really hate bad laws, because what happens when you have laws that don't get updated, for example, to reflect the actual nature of the underlying technology, that's where we see the introduction of ambiguity. So this fight about, hey, should we have access to this data, yes or no? That becomes a bigger skirmish the more ambiguity there is. And the broader the gulf is between what the law actually says and how the technology actually works, well, that's where it comes down to personalities and, internal dynamics and just politics. And I don't think anyone really wants that. No one wants your decision about whether your data is accessed by law enforcement to be determined on, was that law enforcement agent nice to the Google employee? Like, that shouldn't play a role, but the more ambiguity there is, the more gray space that introduces that sort of chance for other considerations than what should really be dictating that determination.
Yeah, it becomes an argument of interpretation and then ultimately like rhetoric in court of who's right and who's wrong, as opposed to very, very clear rules of the road.
And I think everyone appreciates the importance of clarity. Clarity is far more efficient. Clarity is far more fair and just. But to achieve those sorts of laws and regulations, we need a way more sophisticated judiciary. We need a way more sophisticated legislature. But as I was mentioning from the get-go, I don't know a ton of people, especially, let's say, young tech-savvy people, who are saying, I can't wait to move to Salem, Oregon, or I can't wait to move to Olympia, Washington, or you pick the capital. It's just generally not the most attractive place to work. And then you layer on things like remote working is usually not possible for state governments. Sometimes they don't even allow outside residents to work for that state government. So there's a whole can of worms that we need to address to try to get better policy.
Okay. So you were kind of working professionally. You end up going and get your JD. Then you go get your master's in public policy, it sounds like. What originally kind of moved you to Austin or Texas? Like, what initially drew you here? What was the opportunity? Tell us a little bit about UT Law School and kind of the opportunity for you to flex this technology policy muscle here in Texas.
Yeah. So the thing that always caught my attention about Austin was when I first got the job at Google, I had a chance to either live in San Francisco or move to Austin. That's where the offer was. And so I thought, oh my gosh, well, this Austin opportunity sounds pretty legit. I'd never been out here, and I'd heard so many great things. Ultimately, I ended up going to San Francisco because I wanted to get residency to lower my tuition at Cal Berkeley, where I went to law school. Yeah, that money factor. But there was always that piece of me that thought, what if I had picked differently? What if I had gone to Austin? And as a result, half of my team worked in Austin. And so I would constantly be hearing about how much fun they were having. Just the sort of building mentality here of, even though that was about a decade ago, or even more than a decade ago, that spirit of kind of a pioneer mentality of, we're going to go out here, we're going to do things, we're going to mix things up, and hearing about the ecosystem of tech that was out here versus what was a fun opportunity in San Francisco. And I was working down in Mountain View, but Google's campus in Mountain View is awesome, don't get me wrong, but it's just this one monolithic, like Death Star almost equivalent of, you are just all in Google. Mm-hmm. And then when I talked to my friends here in Austin, they were saying, yeah, we went to this tech happy hour and we met these folks doing this new startup thing and they were building this new product. And you didn't get that same vibe in San Francisco because things were just so built out for the tech community. So that seed was planted about a decade ago. And then I came out here during policy school to just meet up with some of those friends and was pretty hooked. So that seed started to germinate. And I was excited about finding a way to eventually come here and kind of fulfill that alternative path that I didn't pick. And so I've been doing work for about 2.5 years now with the Lawfare Institute, which is a part of the Brookings Institute. So I cover emerging tech for Lawfare, and in particular AI. And part of what Lawfare does, part of the, as we like to refer to it, the Lawfare cinematic universe, we have essays, we've got blogs, but we have podcasts. And so one of the quote unquote founding fathers of Lawfare is Bobby Chesney. And Bobby Chesney happens to be the dean of the University of Texas School of Law. And so I was out here another time for a conference on constitutional law and reached out to Bobby and said, hey, I'm in town. Let's catch up. Let's see how things are going. And we talked for 75 minutes, 90 minutes, mainly about AI and mainly about how, in particular, Austin has the opportunity to really help develop the talent pipeline we need for lawyers who actually understand AI, and for lawyers who can engage with founders, for lawyers who can help educate state legislators, and for lawyers who can ultimately help update these outdated policies. So we're riffing on that. We're going back and forth. We're having a great time. And a month or two later, Bobby reaches out to me and says, hey, we want to create this AI innovation in law program at UT. And this isn't going to be like the program at Harvard or the program at Stanford. This isn't about anti-discrimination. This isn't about the ethics of AI. This isn't about AI safety. All of those things are important, and I'm not dismissing those in any regard. But we also need lawyers who are looking to the future and saying, how are we going to realize the full benefits of AI? We're glad that other folks are covering some of those, for lack of a better phrase, doomerism concerns around AI. And who's going to help the folks who are trying to get to AGI and ASI? And who are the folks who are going to answer those really crazy startup founder questions, who are just like, hey, we're building something no one's ever thought of. How does this archaic law apply? And so that's what my program, the AI Innovation and Law Program, aims to do. We are going to recruit and already recruit some of the smartest folks in Texas and around the country. And now they have a chance to come here and be a part of a really exciting tech law program.
That's awesome. Definitely, a few threads that I think are interesting. One is, it seems like lots of big tech has policy groups out here in Austin and in Texas. Like you mentioned, Google has a team out here. I know Meta has a team out here that's pretty active. So I'm curious why that is. I'm sure it's something to do with kind of the ability to recruit talent into a city like Austin, but also how close we are to the state legislature. Mm-hmm. Like, it's literally a 10-minute walk from this office. The The second is definitely agree with you. Like there's lots of, I don't know if doomerism is the right word, but just like these esoteric kind of like fundamental questions about like how do we make sure that AI is non-discriminatory or unbiased and things like that. But there's also a bunch of pragmatic questions of, if AI can draft legal documents with 95% fidelity, like how does that change the work of lawyers? It sounds like that's much more what you're focused on. So that's very exciting.
Yeah, I'd say it's both. So the way I think about it is there's AI for law. So AI for law, biggest name is Harvey, right? Like how can my students use Harvey, be sophisticated with it, and make sure that when they show up at a big law firm, they're the ones who say, whoa, hey, senior partner, let me show you how to use this new exciting AI tool. So that's one thing we definitely want to do. And I'm super excited that we already have a bunch of startups based here in Austin who are going to come to campus and do demos for my students of here's a new tool, here's how to use it. And for anyone who's listening, open invite, please come to campus, come do a demo, come meet the users you want to have. And then the other aspect of the program is law for AI, right? So how do we create the rules and regulations that actually reflect how AI works? So when we think about notice and comment rulemaking, a process for the federal government and state governments to go through and say, hey, we want this agency to promulgate some new rule that applies to this sector. Notice and comment rulemaking is super slow, super time intensive, and usually only benefits entrenched interests. Who takes the time to submit a 20-page blue book footnoted comment to an agency? It's not the startup founder who's taxed on time, who has 15,000 other things to be doing. It's the entrenched player who has, a public policy team of 15,000 people and plenty of money to throw at the problem. And so we need to update how we're actually developing laws, developing our rules to reflect the dynamic and competitive AI ecosystem we want to see. And so I don't know of any other law school that's going to be training their students to help with that work, but that's certainly something we'll be doing here in Austin.
Yeah, it's really exciting. I definitely want to spend the bulk of this time diving into kind of law for AI. But maybe before we get to that, help me understand some of the top things that are on your mind when you think about how AI is already impacting the legal profession, right? What are the new, whether it's specific tools and platforms or other just kind of processes and ways to use AI that you're thinking about and wanting to educate your students at the law school here at UT about?
Yeah, so I think the lowest hanging fruit are some of the rote tasks that we know AI is really, really good at. So some of the use cases of AI that are already replacing or at least augmenting lawyers is discovery work. So discovery is the task, and this also applies to due diligence. Just think about having a stack of 200, if not 2,000 pages of evidence or of a deal and relevant deal documents, and then assigning a junior associate and saying, find the patterns, right? You could do that, right? And it'll take days, if not weeks, and hundreds, if not thousands of dollars. And then someone may need to check that work, and then another person may check that work. What's really good at sorting through a crap ton of data really quickly and identifying patterns? AI, right? So discovery has already been a field where AI and related tools have made inroads, and I think that'll continue to be the case. And so I want my students to know in what context, for example, are those tools most likely to be reliable, and in what settings might they need to apply that extra layer of verification. I think contract writing, any sort of boilerplate contract, and a lot of contracts are boilerplate. Think about an NDA. An NDA usually, and I spent a whole summer reviewing NDAs, and I can tell you about 98% of the time, the language is exactly the same. And it's that 2% where you need the wisdom and judgment to say, hey, is this in line with my client's expectations? So how can I help my students learn how to just get to that 2% and use AI to assist with that? That's another major context. Writing is maybe one of the biggest ones. Learning how to write well with AI is a new skill. right now we focus a lot on just teaching my students and our students how to write generally, which if you've ever written an essay, it's pretty dang time intensive to sit there and think, topic sentence, next sentence, did this flow well? If you know how to prompt an AI tool with sufficient sophistication, you can get there in half the time or a fourth of the time, or who knows. And so those are kind of some illustrative use cases that I think I want my students to know about. But I also want them to be pushing further and developing expertise with tools, for example, that will help them write briefs specific to a particular judge. I want them to be able to think through how to create their own GPTs to analyze some new set of data that no one's trained on before, and develop even more and greater insights from that data. So it's doing the easy stuff and introducing them to the tools that already exist, and also helping them have the literacy so that when the next wave of tools come about, they're ready to go and they're early adopters. Because right now, I think that a lot of law schools are just saying, hey, we're going to give you a 3-hour prompt engineering course your first year of law school, set it and forget it, you'll be good to go after that. That's just not enough, right? We know that prompt engineering is already one of those skills where folks are debating, how relevant is this? Do we really need to spend a ton of time on this? So that's why we want to really focus on that AI literacy component.
How do you think about educating those students? Is it kind of making them interact with the tools? Is it educating them on how the tools work kind of on the back end so they understand the capabilities? Like, what do you think is the most important thing for any lawyer or any person going through law school now to understand about AI so that they can be proficient with tools like this?
I think it's both. So I spend the first chunk of my AI and law course just doing the technical background on AI, because I think if you're a lawyer and you have any interest in going into AI policy, which I want a lot of my students to consider, if you don't know what a neural network is, for example, the idea that you can help a founder get through some murky regulatory analysis or even help draft new laws is pretty low. You need that background of just how does AI actually work, and not in a way that when you talk with a bunch of lawyers, they know the terms. We're really good at sounding smart. We can list a ton of words and we can say all the right things, but if you don't have that really deep sense of understanding about it, and I'm not saying at the level of like some CS student, but enough to really know, okay, what does it mean when someone refers to AI as a stochastic parrot? And is that accurate or not? Or in what context might that be accurate? I want them to be able to engage in that debate in a substantive way.
Can you really quickly dive into what that means and why it's relevant for someone in the legal field to understand it?
Right. So the stochastic parrot point of view, I think and this again is a good example of me trying to sound smart, right? The way that I'd hear most lawyers refer to it is it's just spitting out random words, right? And so like a parrot, it's repeating phrases randomly. And so in the legal context, that leads a lot of people to say it's not reliable at all. And it's dumb, right? The parrot's just spitting out the next best word. And so it doesn't really matter in terms of shaping the future of the profession. It's just humble jumble, not
Monkeys
really
and typewriters.
Exactly. Yeah. Not super useful. It's dumb is what lawyers usually use that phrase to get across. And for me, I think that reveals a lack of engagement with things like Anthropic's great work on mechanistic interpretability. You can talk, as I have, with folks like Joshua Batson, and you go see how Claude is backwards planning how to write a poem. And you can't read a report like that and think, oh, this is really stupid, and there's no progress being made here, and we understand this entirely. No, I mean, if you are engaging with some of the latest research, the folks who are just saying, this is dumb, it's a fad, again, it's just repeating words and making stuff up. Well, in some contexts, I mean, I guess you could boil it down to that. I just don't think that's a savvy take. And so it's really important for young lawyers in particular who can sit at a table with a lot of, let's say, more senior partners And if you have a senior partner who's just super skeptical of AI and, pun intended, regurgitates the line that this is just a stochastic parrot, do you have the confidence to say, hey, well, actually, have you read Joshua Batson's latest report from I mean, I wouldn't want them to actually say that, but to be able to engage in a real discourse with fellow attorneys and with founders themselves to be able to say, hey, help me understand this. And what I also want to convey, and something that I say way too frequently, speaking of parrots, is we really need lawyers to be humble about AI and their technical knowledge. I will be the first to tell you, I have so much learning to do about the technical aspects of AI. For a lot of lawyers, they don't like admitting they don't know what they're talking about. It just feels like, they've done something wrong, or they're not living up to people's perception of a good attorney. I say fall on your sword. The faster you admit, hey, I actually don't know what that term means. Can you tell me about it? The faster you're going to get an advantage over other attorneys. And so I think also to the listeners who are engineers, dumb it down for us, right? Help us out. I think see that we're trying to come from a place of good faith, and also just know that lawyers tend to be really shy about admitting when they don't know things. And we really need a culture where it's okay to admit you don't know everything about AI.
Yeah. I think law is one of those interesting professions where, for something that's very focused on kind of language and writing, et cetera, it's also highly structured, right? There's this term like legalese, kind of the way that you say things in a legal context, that probably lends itself very well to being modeled by a language model. One question I'm curious to hear from you is, I've seen a lot of stories about lawyers using AI and referencing case law that doesn't exist, right? So there's this problem with hallucinations that, maybe if you're generating marketing collateral, hallucination is no big deal. But if you're arguing a case to a judge, it's very, very important that everything that you're referencing and everything that's generated by AI can be tied back to an actual foundational document and kind of ground truth. Like, how do you think about things like hallucinations in law? How do you advise kind of lawyers that you're training to become, active professionals to look out for things like hallucinations and basically make sure that they're using the technology in a responsible way and not spouting things that are not true?
I think this is where having that technical understanding really does come out, to know that AI won't work to just say, or current generative AI models won't work to just say, hey, here's a precise, what we call pin site for that legal claim. It's not going to go into a PDF of a case, precisely identify this page, get the citation perfectly right, and place it in the right part of your brief. That's just not how it works. There's the famous example of lawyer misuse of AI is this case, Mata versus Avianca, where an attorney just submitted a brief without checking it at all that had been generated by AI. And when he was pushed to explain, well, why would you do that? He goes, well, everyone says it's so smart and it's so good, so I just assumed that it would work well. And we all know what we say about assumptions. And in this case, what I really want my students to do is to understand those technical mechanics and understand what it means to verify an AI output. So with respect to hallucinations, right, it's understanding that there are some tasks that AI is really good at. So it will do an excellent job of getting that first draft of the brief in terms of the text. For those citations that are important in a lawyerly context to show that your claims have support, that's not AI's forte. So you just need to distinguish between the use cases for which it's really good and where it sucks, right? And just like a hammer, you're not going to make a cocktail with a hammer. It just doesn't make sense, right? But you have to know what a hammer's for to avoid trying to do a G&T with some random hammer. It just doesn't even make sense. So giving them the context and the knowledge to know when AI is the proper tool, and then having them be able to see how to efficiently go about verifying AI output. But I also want to make sure that they're smart enough to acknowledge the gains that can be had by relying on AI in those contexts, and always leading with one of my favorite questions that I'm stealing from Ethan Mollick, which is, who's the best available human, or how does this AI compare to the best available human? So I get really fed up that we have an article every time a lawyer produces a brief with a hallucinated site. How many hallucinations or errors, right, are the result of a junior associate who's working 90 to 100 hours a week? You think that they're getting every citation correct when they're on that 90th hour plugging away at a brief? Heck no. Do we have an article about every instance in which that occurs? No, right? And to just briefly take this to an even higher level, I get really frustrated by this narrative of AI being insufficiently accurate for a legal context, because to me it reeks of, I've been testing this phrase, I'll call it AI privilege, which is for people who have a lot of money, who have a lot of connections. They can afford a lawyer. They can afford a lawyer who doesn't need to use AI at all, right? They're fine paying as much money as they want to make sure that it was only a human who was doing that, even if that's less efficient, even if that's not going to perhaps lead to as persuasive of writing. It's not an issue. So when they attack the reliability of AI, it's no big deal. And when they perpetuate this idea that AI will never be used in a legal context, it doesn't impact them really at all. When I was clerking in Montana on the Montana Supreme Court, I had to read complaints, right? Statements of a legal issue from pro se clients, people representing themselves without an attorney. Most of the time it was handwritten, couldn't read their handwriting. To the extent I could, it wasn't coherent. I just didn't understand their claims. Imagine if those people had access to this supposedly really crappy AI. Well, at least I can get a sense of what they were trying to say now, right? At least they get to have a chance of their day in court, a chance that otherwise they wouldn't have been afforded. And so when we just apply this kind of elitist mentality to, well, AI isn't as good as my attorney at this highfalutin, big law firm, that's not fair to all the people who could really benefit from AI use cases.
Yeah. One thing I've been thinking a lot about is we hear a lot that AI today can do the work of a junior developer with 1 to 3 years of experience. So like, how does that change what junior developers do for work, or if there's even roles available for junior developers? In kind of a similar vein, for lawyers, if AI can now do a lot of the work that traditionally first, second, third year associates would be doing, like, how does that change the work of the legal profession, right? What does it look like for people graduating from law school today, going in and working at a firm? Are they doing different tasks? Are they spending their time differently within those tasks? Like, how is the landscape kind of changing? And what is the future for new associates that are straight out of law school?
So I think I'm a big subscriber to Amara's Law, which I'm guessing a lot of folks on this pod have heard of. Yeah. So the idea is that we overestimate the changes from technology in the short run, but we underestimate them in the long run. And a related idea is Sayesh Kapoor's notion of AI as normal technology, which we can debate that later if we want to. But one of the more compelling elements of Sayesh's analysis is there's always what he refers to as speed limits to the adoption of technology. And we are really seeing the speed limits come up in the context of law firms adopting AI. So that was a very long and probably convoluted way of saying, right now, the world isn't wildly different for junior associates going to a law firm. And that's mainly because there's still so much hesitancy and distrust around the use of AI tools. I mean, there's still a very vigorous debate around the extent to which submitting information to a model may violate your attorney-client privilege, and essentially disclosing information to a third party. It's a huge debate. It's not necessarily settled among a lot of state bar associations. And so that ambiguity, of course, we're lawyers. We err on the side of avoiding risk. We really don't like doing anything risky, and for good reason, because we're often advocating and defending clients for their most sensitive thing in their life, whether it's a divorce, whether it's a house, whether it's a big business deal. It's really important we get things right. But that sense of hesitation has really slowed adoption among lawyers. So I know in late 2023, for example, I believe the Florida State Bar surveyed attorneys in Florida, and only about 11% said they were using AI in the practice of law. I think in 2024, it may have jumped up to like 33%. That's still really freaking low. And in terms of adoption, we weren't saying to what extent are you actively replacing junior associates with AI, right? We're just saying, are you using it at all, really? So I think there's a lot of time before we see firms replace junior associates with AI. I certainly have heard, and we're already seeing some slower hiring of junior associates because, as you all know, if you're augmenting the skills of someone, making them more productive with respect to those tasks I mentioned earlier, like discovery, like drafting the contract, you just don't need to hire as many people. So I think we're slowly seeing some firms lean more and more into AI. We know that some big firms are actually partnering with some of the largest labs to develop proprietary models so that that concern about violating attorney-client privilege is lessened.
Because it's a private model, so the data is not being passed to
Exactly.
the model to be used for training.
Exactly.
Yeah.
And so that sort of closed universe is occurring. We also know that they're disclosing, for example, some of the largest firms are disclosing all of their emails, all of their briefs, all of their contracts to some of the largest firms to develop even more sophisticated models trained exclusively on or predominantly on their writing style, for example, and their normal argumentation flow. So we see that happening, and that may become more and more common. But for right now, I'd say not much has changed. The world isn't entirely different. We will begin to see native AI firms, though, where all of the sudden they're just saying, hey, clients, we're going to save you potentially thousands, if not tens of thousands of dollars because we are leaning into AI first. And our junior associates don't even bother with trying to draft that version of the contract first and then running it through AI to see what they may have missed. No, we're going to lean on AI from the get-go. And as soon as those take off, and I think they will, because of the savings that clients can receive, then I think we'll really start to see a change in the legal profession. But again, a lot of this is subject to bad headlines, a potential techlash of the more stories we see of, oh, that hallucinated, or this contract included some crazy phrase and led to this weird outcome, may slow adoption.
How does that impact? Because in order to have senior associates and partners, you've got to start as a junior associate, right? So if there's dramatically less junior associates near term, long term, maybe a lot of that work even goes away and can be handled by a senior associate. How do people that are new to the profession break in? Like, how do they get that skill and those repetitions so that they can get promoted and grow within the organization?
This is where I really think there's a ton of pressure on law schools, because law schools historically have been kind of chastised for not teaching lawyers how to actually practice law. You know, we're one of the few professions where basically everyone admits that a graduate from a law school knows nothing. They can't help you, right? Family members, it's pretty funny. As soon as someone graduates law school, they'll say, oh, will you draft my will? Or can you advise me on this landlord-tenant dispute? And a good graduate will probably say, well, no, I haven't spent a ton of time diving directly into that. I mean, they may be able to help a little bit, but they're not ready to really practice law. And that's a huge issue. And it's being accentuated in this period, as you're pointing out, of that sort of missing middle of how do we get that experience so that you can go from being, to be a little pejorative, a little baby lawyer to a real lawyer. How do we make that gap happen? So I think law schools need to take seriously things like how can we do more simulations of meaningful practice of saying, hey, here's a client you're assigned to, figure it out, go help them, go draft a contract with AI, go help them spot issues again with AI, go take on these mock exercises so that you get the experience you would have otherwise had in a traditional world of lawyering without some of these advanced AI tools. So that's one thing, is just getting that exposure through other means. And I think simulations is a really great place to start. We have clinics in a lot of law schools. For example, we have a great immigration clinic at the University of Texas where students get to advise and work with actual clients. And I think those are great. They just haven't been really scaled. There's one clinic at UT that just has space for only 6 students. And so if we want to make sure every student can have these sorts of clinical opportunities, these real world experiences, well, real world in quotes, we need to explore the simulation model. So that's one thing I think we need to do. The other thing that we need to start paying more attention to is thinking about what are the skills clients will actually pay for. And in my opinion, that's wisdom, right? And that's what you may be able to glean from simulations. It's also interpersonal skills. It's also being able to speak well. And again, those are skills we don't necessarily teach in law school. If you've seen Legally Blonde, our foremost legal documentary, we cold call students, we make them speak on the spot. And usually that's an anxiety-ridden affair, and students are hesitant to speak up and get a sense of fear. Well, those are the very skills we actually really need students to be good at if folks are going to continue to pay for them to provide legal advice. Because if you're just relying on the written word, we know that today's AI tools, they're only going to get better, and they're only going to get way better at writing. And so I think there's a real opportunity to begin asking about, should we switch to oral examinations, right? Can we come up with new testing mechanisms to really evaluate if we're giving the students the skills they need to thrive in the age of AI?
Yeah, this idea of simulations is really fascinating. Like, I've seen multiple pitches of multi-agent systems that will go out and will simulate a jury, for instance, right? Where you give a specific persona to an agent. That agent then gets read a case with a bunch of evidence and witnesses, et cetera, and then they kind of have to negotiate and come to an answer. I think AI can play an interesting role in tooling that enables some of those simulations to give people more reps and at-bats to kind of augment maybe the gap that's being created where there's now less work as kind of a junior associate lawyer.
Yeah, and I love that you shared that, because I was actually talking with a lawyer today who was just thinking of today's AI as just the last iteration of AI seemingly, and saying, well, this model only works in this particular way and it gave me this one output and it didn't demonstrate this sort of behavior. It's like, man, have you not heard of these things, AI agents? Didn't you know 2025 is the year of the agent, according to any tech article? And I just think there's a lack of creativity among lawyers to see what's coming around the corner, to realize that we can develop these really sophisticated simulations, as you were pointing out.
Yeah. Well, so pivoting a little bit to policy around AI, right? AI law itself. Kind of set the stage for people. What is the current state of legal regulatory policy around AI in the US as it exists today?
In short, it's a mess. So when we look at the federal level, Congress has yet to get its act together. So in the immediate aftermath of the release of ChatGPT, I guess it was probably 6 months later, we had the Senate AI Insight Forum. And this was where then Majority Leader Schumer had a bunch of AI experts come and testify in closed room hearings about what the biggest issues were around AI. At that point in time, which seems like eons ago, it was predominantly kind of that doomer mentality. We had a lot of folks, and even Sam Altman, going and saying, hey, you need to regulate us now, because if you don't, it may cause the end of humanity. And this was a moment where on the Hill, everyone had a P-doom, and suddenly even the chair of the FTC at the time, Lena Khan, had a P-doom, and it was just, what the heck are we doing? Then the pendulum has since swung, and so we just had the release, for example, of President Trump's AI action plan, where we've seen it declared that it's the policy of the United States that we will achieve AI dominance. And so obviously that's a quite different narrative. And between those 2 points of pursuing AI dominance and then earlier having this sort of doomer mentality, Congress is just unsure of what it should do. And really what we need is Congress to act and say, hey, this is our framework that we're going to regulate AI on, and really clarify the AI development space. And I specify the term development because we know that model development is incredibly costly, billions of dollars, lots of time. It's getting more and more expensive. That's the sort of interstate commerce that the founders always intended to operate at a national level, of making sure that one state, for example, couldn't dictate the entire economy or undermine the entire economy for that matter. And we can get into con law and the Articles of Confederation if you really want to nerd out, but I'll save that for another pod. So at the federal level, the short story is we haven't seen clarity from Congress, and Congress will ultimately need to be the actor that sets this forth, because for anything that's relevant to AI development, such as copyright, for example, and fair use ramifications of training data to make it to the Supreme Court, that's going to take years. And even if an issue like whether training data is covered under fair use, the fair use exception of copyright law, that's going to be a very narrow opinion. So the Supreme Court may address one thing, but that's still going to leave tons of open questions around AI regulation. The president can only really dictate what's going to happen in the executive branch and among agencies. So the president can, for example, and as President Trump is doing, reform or direct agencies to streamline certain regulations. So the AI action plan, for example, is trying to ease the extent to which we can bring on new sources of power, trying to ease permitting around the creation of data centers, taking all of these steps that are just specific to the government itself, but can't necessarily help with the broader AI regulatory ecosystem. So in that void, states are becoming some of the main actors in developing AI laws. And the problem is some states want to veer into that AI development realm. So, for example, in New York, there's the Responsible AI Safety and Education Act. And under the RAISE Act, for example, some of the largest models are forced to comply with a set of procedural expectations and disclosures to align with basically the values and priorities of New York legislators. Those values may be fine and dandy, and I agree they're probably coming from a good spot. But again, do we want New York dictating how the largest models that are going to be used by Americans, all 400 million of them, should we give that power to New York alone? That's an interesting question. So we also have states that are pursuing what I would characterize as AI use, right, or AI deployment regulation. And I think this is more in the sweet spot of where states can act and should act. So California, for example, is looking at, hey, in what context do we want nurses or medical professionals to be able to use AI? That has no bearing. If a nurse in California has to go through however many hours of training for AI use, that doesn't change at all how nurses here in Texas, for example, are able to use AI. And so that sort of legislation I have no qualms with. But at the state level, we see hundreds of AI-related bills currently pending before state legislators. So it could get really wild really quickly. I think everyone who's a listener to any tech podcast or just attentive to the tech landscape generally will have heard of the privacy patchwork and how I think we're up to at least 14, if not more, if not 23 or nearly half of states have some comprehensive privacy act. that is a compliance nightmare, right? You can go talk to any founder and they'll tell you how expensive it is to hire outside counsel to go analyze some new state law to see if they're compliant with this privacy framework. Now, imagine doing that in the AI case where states have different definitions of AI, they have different entities that are regulating it, they have different case law that's going to develop interpreting those laws, and it just gets really gnarly really quickly.
Yeah, so the problem with states regulating themselves is, one, it creates this regulatory overhead that generally only the largest companies have the resources to deal with. And so then that chokes out kind of new entrants. But then two, you're having to deal with not being able to go into this certain market, or just kind of changing the way that you run your business to kind of deal with these very specific laws in just a specific geography, as opposed to having kind of one common case law or one common set of regulations that everyone can follow and comply by.
Exactly. And I think too, it's worth raising that some folks who are real advocates of even the most comprehensive and wide-reaching state AI laws will say, oh, but there's a carve-out for startups, so we're fine. That doesn't impact the AI regulatory ecosystem. But if you're a closed model developer and developer of the largest closed models that are covered by those acts, are you going to keep your prices the same when all of a sudden you have all these new compliance costs? I don't think so, right? Someone's going to pay for all that additional compliance, and I don't think it's going to be the company. And you know more than I do that there are a lot of companies right now building on, let's say, ChatGPT or building on Gemini. And if that becomes more costly, well, then that's going to get passed on to someone. It's going to appear somewhere in the AI ecosystem. And so I get that there's a lot of good intentions around state AI regulation. What I worry most about are the unintended consequences that we may not realize until after the fact, or may not realize generally. Those opportunity costs of, hey, there was a founder who was thinking of releasing this product or thinking of developing this product, but ultimately, some lawyer said, oh, I don't know how this law applies to you, or I don't know if it will apply to you. And if that founder got discouraged and didn't release that tool or didn't pursue some new innovative thing, well, my tired line again is innovation delayed is innovation denied. If we don't have founders being able to develop new products as quickly as possible, then we're going to miss out on the spillover inventions and the spillover connections that could have been made sooner.
Yeah. One thing I'd love to dive in with you is, you mentioned President Trump's kind of AI dominance set of kind of guidelines, and how he's basically commanding agencies to make it easier to develop the infrastructure that we need to build and deploy AI at a larger scale. Let's talk a little bit about why that is different than Congress actually passing legislation, kind of bringing people back to government back in high school, right? What are kind of the different roles that different branches of the government play in setting the rules of the road for how AI can be used? Mm-hmm. And why is it that this new set of policies pushed forward by the Trump administration are not actually a set of new regulations and policies around AI, but are instead just executive actions?
Yeah, so Congress has all of the powers afforded to it under Article 1, Section 8 of the Constitution, just to go full con law nerd, right? So
and Congress is Senate and House of Representatives.
Correct, yes. So each branch of government only has the powers specifically assigned to it. So we've got the legislature, Congress, made up of the House and Senate. We have the judiciary, led by the Supreme Court, then the circuit courts and the district courts, and then there's the president. And the president,
and the broader executive office.
The president oversees the executive branch, which is made up of a heck ton of agencies. The powers afforded to the president are very narrow, right? With respect to certain delegated or certain specific tasks that the president alone can act on. So, for example, serving as the commander in chief. Only the president can do that. Signing laws. Only the president can do that. The president also has authority over executive agencies and agencies generally within the executive branch. But it's Congress that gives the initial direction and power to these agencies themselves.
So Congress passes a law that says, hey, let's create this administration like the EPA, right?
Correct.
The Environmental Protection Agency. And that agency will be created through this legislation to protect the environment. And then it's up to the president to actually define how they go about doing that work. Is that kind of the right way to think about it?
Right. Yeah, I'd say it's the executive branch that then thinks about it. So the president is allowed to delegate extensive powers to agencies and agency heads, or Congress may say, we want this specific agency to make this specific decision or this kind of decision. And the president can help with that effort or advise that agency as to whatever the president wants to prioritize or their general guidance for interpreting different laws. So Congress can't write every single rule. For example, think about the fact that we need regulations for speed limits. We need regulations for what drugs get developed and how and what safety standards apply. Congress, not to knock Congress too much, doesn't pass a heck of a lot of laws, right? They're not known right now for being particularly action-oriented. And so agencies are the ones who fill in the gaps, and they're the ones who promulgate rules. So rules are the kind of lower level laws interpreting what Congress has set forth. So if Congress says, hey, we want clean air and water, develop the rules to make sure that happens. And so what the president can do is shape how those rules will come about by, for example, appointing different agency heads. So if you want an agency to have a particular focus on one area or another or a particular bent, you're going to appoint a different person. The president often has a key role in the appointment of those agency heads. Congress oftentimes has an ability to assist with that decision, or the Senate does. But then it's the agencies themselves who are going through using their expertise to say this is the proper rule to effectuate Congress's desire. Well, in the context of AI, what we can see is Congress has already passed laws. Let's say, for example, NEPA, which applies to what environmental protection checks we need to go through before we take on certain projects. Or Congress can pass the Clean Air and Water Act, the Clean Water Act or the Clean Air Act. So then it's up to the president and the agency, specifically usually the agency, to think through, okay, how are we going to enforce and how are we going to interpret that law? So one way this is particularly relevant to AI right now is how are we going to use federal lands? So Congress has delegated or instructed, for example, the Department of Interior, the Department of Energy, and other agencies to have particular roles in how we use federal lands, for example. Well, now the president can dictate and specify how they want those agencies to take on those tasks. So we're seeing, for example, a change in how we're interpreting certain laws around the use of federal lands for things like data centers, for things like power development. And so that's kind of a very speedy overview.
No, it's helpful. So legislature kind of creates a law for the whole country to abide by that's really kind of high level, like, hey, this is what we need to achieve. And then in terms of effectuating that high level goal, the agencies themselves, with direction from the executive branch and the president, can shape kind of the lower level rules of how that actually gets effectuated.
Exactly. So the executive is tasked with enforcing the law, but enforcing the law often requires thinking through those nitty-gritty details and oftentimes involves a lot of prioritization. So, if you are the executive and you're helping think through what resources are available to an agency, or how do you want to put different political weight between the enforcement of different rules, the president can have a really big role in shaping those decisions.
So the president can say, hey, I actually don't want to put a bunch of resources towards making sure that clean air rules, or there are new clean air regulations, right? Instead, I want to put those resources towards this other thing.
So this gets into a pretty naughty KNOTTY, pretty naughty area of constitutional law about the extent to which the president can kind of ignore what Congress has instructed. If Congress says, hey, we want you to spend $500 million on this project, the president typically, depending on who you ask, but most lawyers would say the president doesn't have the ability to ignore that clear intention of Congress to use that money in that way. There's also limits on the extent to which agencies can just kind of make rules that don't align with Congress's intent. So agencies are bound by Congress's intent. And this gets to the what's referred to as the major questions doctrine. So if an agency out of nowhere, seemingly out of nowhere, interprets some grant of authority, let's say Congress instructs the EPA to oversee the development of some clean water project, and it's specific to the Southeast. We want you to do some clean water project in the Southeast and go and do it. And the agency then develops a national rule or something like that that may impose costs of billions of dollars on companies across the country. Well, that's way more expansive. That rule they're promulgating is way more expansive than what we would seemingly say Congress agreed to, right? So Congress was just saying, hey, we want you to do this little thing in the Southeast. If the agency all of a sudden says, oh, so you meant do this massive project across the country, right? There, the courts would come in and say, whoa, you're not acting pursuant to what Congress told you to do. So in all of these interesting contexts, we have to think through what is Congress saying, what authority has been specifically delegated to an agency, and what leeway does the president have in shaping that. Now, it's important to also flag that in some contexts, the president does have discretion to kind of set policy alone. So national security, with respect to being the commander in chief, the president's going to have some ability to say, hey, we are really going to lean into, tackling, let's say, China with respect to how we're interpreting AI policy or what we're going to prioritize.
So this kind of brings me back to this kind of like push towards or thrust for AI dominance from the Trump administration. Like, what authority is that under? Because that's not taking something from Congress and then figuring out how to effectuate it. That's actually creating kind of a new slate of initiatives or policies within existing organizations to push for more AI dominance. Like, help walk us through kind of what this is going to look like. Is this new policy? Is this just a reinforcement of how different rules are implemented? Like, what does it actually mean, and how is it going to affect us as citizens?
Yeah, so it's a big deal because agencies, as understood by a lot of legal academics, generally have to adhere to whatever the president directs them to do. And so within the bounds of whatever Congress has initially delegated to that agency. So the Department of Defense, for example, can't all of a sudden start going into the land of consumer protection, or the EPA can't suddenly start regulating airlines, right? Mm-hmm. So this is all within certain confines. But again, the president can change internal policies of those agencies. The president can specify what should be prioritized within those agencies and try to direct what they're going to focus on most. The key thing to realize about executive actions, though, executive orders, interpreting the president's policies, for instance, is that they can be completely changed as soon as a new administration comes in. So the second that President Trump came into office the second time, he announced an executive order basically wiping out all of the executive orders that President Biden had put in place with respect to AI policy. Mm-hmm. So President Biden was saying, hey, you federal agencies over which I have broad discretion for their operations, not necessarily what they're tasked with doing or what Congress has allowed them to do, but how they operate, what they prioritize. Again, President Biden had his AI Bill of Rights, for example, and had his executive order on AI really prioritizing some of the more ethical aspects of AI and safety safety-oriented aspects of AI of, hey, you federal agency, if you use AI, then we want you to be documenting how you're going to make sure it's being used in a fair and ethical manner, and we want to see that certain considerations were taken into account for certain communities, for example. And so that was President Biden's orientation, and his executive order oversaw that. President Trump comes into office because it's an executive order. It's not law in the same way that Congress passes a law. President Trump has the ability to just wipe those off the books and say, hey, agency, I actually want you to do a 180-degree pivot. So that's just the important thing to point out. We could see if there's a new administration in 2028, they could completely reorient how agencies think about AI. So that's one important thing to point out, is that there's a very finite temporal aspect to this AI executive order and this AI action plan. It does have a big effect and may have a very big effect on our day-to-day lives. And I say if for a couple of reasons. The AI action plan had 90 policy recommendations. And those policy recommendations span from directing the Department of Education to focus more on AI workforce development, to encouraging the Department of Defense to lean into, for example, having its senior military colleges focus more on AI, to having, again, the Department of Interior and the Department of Energy think through new ways to bring on power plant projects in a more expeditious fashion. Those are really big tasks and monumental in terms of getting
those are policy recommendations.
So
right?
they're the policies from the president directing an agency.
Got it.
And
so it says, hey, within your purview as the Department of the Interior, I want you to do these things.
I want you to do these things. In theory, the head of the Secretary of the Department of Energy, for example, could say, no thanks. Cool. What can the president usually do? Then dismiss that head.
And place in someone else that's more
attempt to place someone in, but again, in certain contexts, that person who gets nominated would have to be confirmed by the Senate. Mm-hmm. And so there's a lot of weird politics that can play out if you get folks in government specifically in the executive branch who disagree with the president. Lots of shenanigans can occur. One thing that a lot of political observers have noted is that this time around, the administration has been very strategic about making sure the people who are in place at the heads of agencies are willing to adhere to President Trump's guidance. And so we don't have a whole lot of expectation that agencies are going to ignore what he's calling them to prioritize.
So let's talk about some of that guidance, though, and prioritization, right? Within this AI action plan, what are some of the new ways that we as the U.S. are thinking about amplifying AI and AI development?
So there are three buckets or three pillars of the AI action plan. There's AI innovation, there's AI infrastructure, and there's international AI diplomacy and security. On the AI innovation front, there are a couple things that really stand out. The first would be that focus on AI adoption. And so the president is really looking for the Department of Defense, for example, and federal agencies generally to adopt AI more and more into their workflows, right? And make sure they're leaning into that. And also directing them to interpret law in a manner that aligns with expediting and accelerating AI innovation more generally. So we're seeing that there's a pretty big push, again, for bringing on more startups by virtue of leaning into open source development, for example. So probably the biggest recommendation, or the recommendation that received the most attention in that AI innovation pillar, was a call to really focus on open source projects. And one way the federal government can assist with that, for example, is using its procurement power. So the federal government is one of the biggest customers anyone can land, right?
They buy a lot of stuff.
They buy a lot of stuff. They've got a pretty big budget, and it's growing. So if you get a deal with the federal government, that's a pretty sweet place to be. And so if the federal government says, hey, we're only going to buy this kind of model, well, then that shifts economic incentives for a lot of actors.
Absolutely.
And so if the federal government says, hey, we're kind of leaning into open source, that's going to redirect a lot of what we see in the AI community itself. In theory, that's how it can play out. So on the AI innovation front too, I'd say that there's calls, for example, to make access to federal data sets more ubiquitous. So for example, in the science context, there's a call for any scientific funded projects from the federal government. That data should then be shared openly so that downstream developers can now have more and more access to really great training data. One of the things that's been pretty widely applauded as well in that innovation pillar is a call for using AI more for science. So looking at how we can accelerate scientific advances using AI, and that can look like the NSF, the National Science Foundation, prioritizing grants, for example, to projects that are AI-based, that are using AI to try to get that sort of recursive AI development and learning that everyone is talking about and hoping for. So that's the innovation bucket. And there, if adhered to and if brought to realization, could be super meaningful. And my hesitation there, or my qualification there, is some of these agencies are they have smaller budgets than other agencies, and so there's just a resource question of how much can you make sure these policies get effectuated as soon as possible. For some of these agencies, it's a question of expertise, of do they have the right people in place to be able to effectuate these policies. So we'll just see how that works out. The second bucket, AI infrastructure, is all the work that's being done by the Department of Energy, for example, to streamline ways to bring in particular, geothermal and nuclear power development. And so this is a pretty big swell change from just about every decade since 3 Mile Island of saying, hey, we're actually going to lean into nuclear energy as something we want to see come about. Obviously, if we were to see a bunch of nuclear power plants brought online, that kind of changes the game in a lot of ways for AI development.
So they're focusing on that because it's necessary to build out more AI infrastructure, right? So one of the ways that they're impacting it is they're saying, hey, make it easier to build nuclear power plants, because if we have more nuclear power plants, we'll have more available power to run data centers and train more models and things like that. Exactly.
So I think that the folks at the Institute for Progress highly recommend all of their research, in particular Tim Fist's research. I believe, and may need to fact check me on this one, China may have brought on 400 gigawatts of energy in the past year, which is just bonkers. I mean, multiple massive cities worth of power. I think the US brought on 2, right? So it's just, we're really far behind in that energy availability, and energy is essential for inference in particular, right? If we're going to be able to power all of these data centers to allow for folks to be using, training models and reasoning models, we're going to need way more power to be available for more users to use AI in more cases. And so by virtue of trying to facilitate that, the president's really trying to say, we want to make it easier for these AI developers to come up with the best models as soon as possible. Another aspect of this AI infrastructure prong, one that maybe hasn't received as much attention, is calling for the development of the workforce that can do those AI infrastructure projects. So creating a data center, you need really good plumbers for all the water features that have to be involved with keeping things systems, cool. Exactly. Yeah. How many plumber friends do you have?
Very few.
Very few. That's kind of shitty, pun intended. But, we need plumbers, we need engineers, we need electricians. Those folks are kind of few and far between. We've been talking about how important apprenticeships programs are for a long time, but those haven't always done particularly well. And so this executive order, this AI action plan saying, hey, Department of Education, I want you to begin to work with middle schools and high schools to develop what they refer to as pre-apprenticeship programs of helping more students learn about AI opportunities. So pretty interesting there. The third bucket, or the third pillar, is that international AI diplomacy and security. And this includes some of those AI safety related risks. So a big concern among the administration, as evidenced by the AI action plan, is cybersecurity. How are we going to make sure that model weights, for example, are protected and not hacked into or stolen in any way? How are we going to make sure that data centers are secure? How are we going to prevent the use of models to perpetuate some of those CBRN risks? So chemical, bioweapons, radiological, nuclear, and I'm blanking on E, which is extremely embarrassing.
Energy, maybe?
No, maybe it's energy.
This class of risks.
This class of risks, my goodness.
Yeah.
So those CBRN
Malicious
risks,
uses of AI models,
malicious use, yes,
yeah.
we're very attentive to that in this AI action plan of saying, hey, that's a real concern. We want to prevent the odds of bad actors being able to perpetuate those sorts of AI harms, and so that's a consideration. Then we're thinking through how do we make sure that American AI tools are the sort of tools of the world. How do we make them the most ubiquitous, the most common? Because we want people building on US systems, not building on Chinese systems, for example. And so what strategic steps can we take to work with allies and partners?
So US chips, US models, US data centers,
Exactly.
US infrastructure, US explainability tools, like everything.
We want our AI stack to be the stack that dominates within reason. And this is where it gets really complex of, hey, if we know that a country hasn't proven very good at making sure that chips that they import from the US stay within those borders, maybe we're not going to export those chips to that country, right? How do we know they have the laws in place to avoid that sort of smuggling? We should be getting more clarity around these export controls, which dictate who can import how many chips and what quality of chip. Down the road, we saw President Trump change and rescinded the export control rule that was put in place by the Biden administration. So we're still waiting for more clarity there. But what this AI action plan tees up is giving us the knowledge that we want to make sure that folks are buying from and using AI companies based in the US. What that looks like in practice is going to shake out a little bit.
Okay, so these are all kind of the initiatives by the executive branch that for at least the next 3.5 years are going to be how the executive branch is encouraging AI development, AI implementation, et cetera. Obviously that could change if a new administration comes in 4 years later, but a lot of things will have happened in the meantime. Shifting over to the formal policy side, what is the role of the legislative branch for creating policy around AI? What are some of the hot topics? Really early in the conversation, you mentioned things like fair use and copyright, et cetera. Where are the areas that you think the legislative branch is going to get active over the next 3.5, 4 years to create actual policy around AI that's a little bit more durable and not prone to shifting when new administration comes in?
So I think that intellectual property, as you pointed out, copyright is one of those biggest questions of copyright law has generally looked the same since the 1970s. A lot has changed since the 1970s, right? And so clarity around whether AI companies can use copyrighted data for training would be great to come from Congress.
And you mentioned that this is part of the interpretation of what's called the fair use doctrine.
Right.
Can you explain fair use doctrine for like a 10-year-old to understand?
Yes. Yeah. So for a 10-year-old to understand, so when somebody receives a copyright, generally the idea is they alone get to exercise the certain bundles of rights with respect to that copyrighted material.
So like creating new content around that copyrighted character or storyline.
Exactly. So there's a reason why only Marvel gets to make its Marvel movies, right? They have copyrights around certain characters. And so you, Jake, can't go out and create Smarvel movies that are based around the exact same characters, but just with slight misspellings like that, right? Marvel owns a copyright. They alone can exercise certain reproductions of that material. They can choose to license that material to other folks and specify what exact rights they're going to delegate to that other person, but that's all up to Marvel or the copyright owner. The fair use exceptions say, hey, we want to make sure that in certain contexts, we allow for the use of that copyrighted material. So, for example, in education generally, we allow for the reproduction of copyrighted material. So, for example, as an educator, I can usually pull an article from the internet and make it available to my students because we want the free-flowing information to students to learn, to have access to knowledge, and all those good things.
So that's not covered by copyright. That's part of the fair use.
It's covered by copyright, but there's an exception for that use,
okay.
right? So we say that is copyrighted, but we're going to allow the reproduction or the use of that right that we otherwise wouldn't. But because of this specific context, we're okay with it. Generally, there are a couple well-known specified exceptions, like that education exception, journalism. Usually, there's some flexibility around reproducing copyrighted material because
for the purposes of reporting on it.
Exactly, right? So we're okay if there's, and again, because it's the law, there's a ton of ambiguity, but we're okay if a newspaper includes in its photo of a Disney story a picture of Mickey Mouse doing something, right? Because it's not like we're trying to diminish the value of that copyright to Disney. No one's saying, oh, well, now I see this photo of Mickey Mouse, I'm going to cut that out and duct tape it to my shirt or something like that, right? Denying Disney the ability to sell you a Mickey Mouse shirt. We're just not concerned about that. But then for contexts that aren't explicitly listed as within that exception, that's where we get into the fair use consideration. And that's where we have 4 factors that the courts will usually weigh. And the most important factor, the one that is determinative in most cases, is what's known as this transformative prong. Are you taking that material and then transforming it in such a way that we think it's worthy of its own sort of protection, or it's distinct enough that it is adding new value or adding new insights that otherwise wouldn't be covered? So one example is, and this is another hotly contested one, but and I won't dive too much into the case law here, but think about Andy Warhol and the use of Campbell's soup. Right? So you have that Campbell soup can, iconic, covered by copyright, owned by Campbell Soup. But a big question, did Andy Warhol, by virtue of putting it in this new painting, in this new light, does that qualify as transformative, right? Is that something that's distinct enough?
Did he transform the Campbell's logo enough in a distinct enough way,
right,
to where it can't be claimed by Campbell's as I own that
copyright. As infringing upon its copyright, right?
Yes,
or not falling within that exception. And this transformative question is really, really hard.
Yeah.
Depending on who you ask, some people will say it's a sort of I know it when I see it type thing. Well, that doesn't sound great from a legal perspective or from a rule of law perspective. Other people will say, it's about social utility. Did this new use add to the public value, create new knowledge and otherwise benefit people? So this is one of the biggest questions for training data and whether the use of copyrighted material in training infringes upon a copyright. And generally we say yes, right? You're almost clear, you're unequivocally using copyrighted material. So yes, you are infringing it, but does it fall into that fair use exception? And in particular, is the use of that training data, that copyrighted material transformative when it goes through that process?
Okay, so just to kind of pull that thread a little bit, the question is, if the model, the model is using copyrighted data to be trained on, is that okay? That's one question.
So we've answered that question.
Okay.
It's yes. Yeah, it is using copyrighted. No, well, I'm just saying it's using copyrighted material. Full stop. Yeah.
But then the question becomes, is that legally permissible?
Is that you're right?
Do the model people owe something to the people that own the copyright?
Exactly. So if it doesn't fall within the fair use exception, then yes, they violated a copyright.
So the second thing here is, can you steelman the case for AI being transformative and making that kind of legally permissible under fair use?
Yeah, so I think it really hinges on that transformative use case of an output from an AI model, right? And what we're seeing by virtue of that training process is so wholly distinct from the underlying work that it is adding tremendous social value. I think that's the strongest argument to be made of think about all of the things we're able to do with generative AI, the amount of new knowledge we can create, the amount of expanded access to materials by, for example, taking that New York Times article and perhaps, or those millions of New York Times articles, and now you're coming up with new novels, new ways of sharing information. So it's just incredible what can come about there. The opposite, the counter here.
Yeah, Steelman the opposite.
Yeah, is, hey, well, think about the use of generative AI by Google in their search function. And it's taking specific copyrighted material, the articles you would have otherwise clicked on, and in some cases, the articles you would have otherwise had to go through a paywall to access. And it's now regurgitating, or variants, a messy regurgitation. It's creating material that is acting as a sort of market substitute for that good. And so now we're not talking about the transformative prong of the 4 fair use factors anymore. We're talking about the market substitutability, which other people hold up as the most important factor of saying, okay, are you using this in a way to serve as a replacement for the good that otherwise the copyright owner could have profited from?
So another example here would be, you could, for instance, I've done this. I've taken, photos of myself and say, hey, make this Pixar style.
Exactly.
And I specifically reference Pixar, and then it generates the same photo, but it looks just like a Pixar animation.
Right.
So the argument there is, I otherwise would have had to go to Pixar and give them business to design this photo of me in Pixar style.
Exactly. And so if folks decide to uplift that factor as more important, then the cases can come out otherwise. And we've already seen in one single district, so the Northern District of California, 2 judges have reached different conclusions about whether using copyrighted data qualifies under the fair use exception. And so that level of uncertainty isn't helpful for anyone. And this is where Congress can come in and say, hey, in these instances, the use of copyrighted data.
So they can create the rules for the
They
road.
can create the rules for the road. So this is an instance where the president can't come in and say, hey, this is the new law of the land. I'm going to rewrite a law of Congress, right? That's not permissible. It needs to be Congress that acts here. The other key thing that Congress can play a role in is, instead of these sort of small interpretive changes that we're seeing, for instance, with respect to the use of federal land or the interpretation of the Clean Water Act and whether the creation of data centers falls into certain exceptions there with respect to enforcement. Congress can just say, hey, no, this is the new version of this law. We're going to amend this law to explicitly authorize this or specifically foreclose that. And that then becomes clear as day the new law.
It's really in the absence of clarity from Congress that the executive branch gets more purview and power, or on the other side, the judicial branch, right? Because if Congress doesn't come in and say, hey, here's the rules for the road of copyrighted materials and AI models, then what will happen is it'll work its way out in the courts. It'll eventually go to the Supreme Court. The Supreme Court will have to just interpret the existing law, and then that becomes a new kind of case law that everyone else has to abide by.
Exactly.
Is that kind of how
And
it
it's
works?
really important, too, to point out that there's a reason we want Congress to be the branch that's setting these rules, is because the Supreme Court, for example, Justice Kagan has said with respect to an internet case, we are not the 9 foremost experts on the internet. Well, if they're not the experts on the internet, they're certainly not the experts on AI, and they can receive briefs from outside parties that help them fill in the blanks, and obviously advocates before the Supreme Court, the folks actually litigating the case, try to do their best to educate justices, but they're really busy. They haven't taken CS courses. Their clerks probably haven't taken CS courses. So the odds of them really grokking, sorry, bad AI joke there, I guess. The odds of them really understanding the technical ins and costs of AI are pretty low. So that's not great either. And then from the executive point of view, these are temporary, right? As we've noted, a new president can come in and wipe out whatever executive orders had been in place. And again, there's a question of democratic legitimacy of agencies usually allow for that notice and comment rulemaking that I mentioned earlier. But as I said then too, who actually participates in that? It's usually not your average Joes and Janes. And so Congress is where we want to have this clarity. It's where we want to have national frameworks developed. And Congress can be the one to say, hey, we really want to lean into nuclear energy. We really want to take this approach to copyrighted material. We really want to, for example, make it easier for startups to access different kinds of investments and investors. All of those things, Congress can accelerate and make more stable and enduring.
Yeah. So Congress, do your job.
Yeah.
Listen to experts, listen to your constituents, and make rules so that the rulemaking doesn't fall to these other groups where that's not their core competency.
And stop states. There you go. Dual assignment, Congress.
Yeah, right on. Shout out Congress. Moving to maybe the other side. So copyright, it sounds like definitely going to be some legislative movement on that front, hopefully, if Congress does their job.
Right.
But at the very least, we'll get some sort of interpretation from the courts, as we've started to see already. What's an area of policy or things that'll need to be regulated from the legislative branch, like legislatively regulated, around AI that you aren't seeing as a hot topic but think are very important?
Well, I'll pick one that I do think is a hot topic, but maybe isn't as popular among the general public to know of as a really important issue. And this is the issue of liability. Okay. Who do you hold responsible when there's an AI harm? So a lot of people, I think, have thought through this in the context of AVs. Yeah. Right?
AV, autonomous driving, right?
AV, autonomous vehicles. Yeah. So everyone's, probably seen a video of a Waymo or a Tesla AV all of a sudden going off the rails, or I guess off the road. And let's pick a really docile issue. Runs into a stop sign. Who pays? Is it Tesla? Is it the engineer in particular who maybe had the leading role in developing stop sign inquiries? Is it, if there were a driver in the car, is it them somehow because they didn't grab the steering wheel at the proper time? Depending on the level of the AV, there's different levels of sophistication for autonomous vehicles. These are big questions of who we want to pay. And what's even trickier is we know, of course, there's the black box issue of AI of we may not be able to go in and say, hey, this is precisely what it was thinking at this time, or because it was trained in this specific way, we can blame that engineer or this engineer. There's just so much complexity toward assigning blame. So now think about that in the context of some of these massive models of you have someone using Gemini or using ChatGPT in a sensitive business use case, and it hallucinates. And as a result of that hallucination, let's say millions of dollars get lost in some business transaction. Who's to blame, right? Does the business who was wronged get to point their finger at OpenAI or Google and say, hey, we want money for whatever happened? Or is it on the deployer of that AI, the end deployer of that AI, that company that decided, hey, we're going to use Gemini or ChatGPT in this context? Now let's make things even more complex. Open source model gets used by an end deployer, and they fine tune it just a little bit. Let's say it's very marginal. Does that marginal fine tuning mean that Google gets to avoid responsibility for the use of Gemma, or Meta gets to avoid responsibility for Llama? Okay, but now if it's a lot of fine tuning, right? A ton of work to make an entirely different model. How does that change the liability equation? Okay, so those complexity is already there. Let's make it even worse. Let's imagine it's a cyber attack facilitated with an open source model of unprecedented damage. Just completely disrupts the economy. Who then? What happens in that instance? And so those concerns and those questions of liability are massive legislative decisions that have to be made, right? Someone has to be accountable. We need to make sure that folks that are wronged can be righted. That's kind of the basic idea of the law.
The justice system, yeah.
Right. Getting that right, though, is really tricky. And right now, there are a lot of states considering laws about who should be held liable for what sorts of damages. So, for example, that RAISE Act I mentioned in New York earlier had ideas around for certain instances, certain levels of harm of perhaps millions or hundreds of millions of dollars. They were trying to develop a scheme for when large AI labs could be held liable for those harms if they didn't use the proper degree of care. Well, what does the proper degree of care mean, right? I could ask 10 engineers what they think is the appropriate way to train a model, and I'd probably get 20 different answers. So do we want a state legislator to decide what they think the proper standard of care should be? Or do we want state courts to decide what that should be, right? Moving on a case-by-case basis of, hey, we saw this harm. Now we're going to analyze the training practices of that lab. Do we think that was reasonable care? All of that adds up to potentially bad law or potentially unclear law. So this question of liability is another really good instance where we need a national approach so that we're not dealing with 50 different equations for who's held liable in what instance. In some ways, tort law is an area that's always going to
Define tort law.
So this is when there's some sort of civil wrong that occurs to which we need some remedy. Someone needs to be made whole. So there's some harm that occurs, and then we're looking for who's held liable for that instance. Some instances of those will always end up being state law, so we'll have to see some legislation there. But on some of these broader questions of liability, Congress really can come in and clarify things.
Yeah, so do your job, Congress.
Please.
And in fairness, like, it doesn't make the issue any less complex, right? Because you still, if you're creating some of these liability legislation at a national level, still going to have 20 different opinions on what defines like a substantially edited model versus like a base model versus all these other things.
Right. And Congress...
But at least it's one consistent set of rules.
It's one consistent set of rules. And it's one standard of this is what qualifies as reasonable care, for example, rather than 50
And then you can
ones.
build case law on top of that like we have with things like fair use up until now.
Exactly.
That gives it, makes it possible for people to continue operating.
Right. We'll refine it over time, refine our understanding of it over time. And agencies can promulgate rules further specifying, hey, here's what the standard looks like. NIST, for example, can assist with that, doing research into whether that standard is working as intended. There's just a whole lot of room for improvement there. But there's a reason why we don't have 50 different standards for how cars are supposed to be made, right? If each state got to dictate how many wheels a car could have, that's not going to go well, right? Yeah. Hopefully we would all end up at 4, but that would require perhaps a lot of time and a lot of fights. It'd be better if Congress just said, hey, yeah, cars are going to have 4 wheels or what have you. That may not be the best example, but sorry to all those folks with the weird, cars. Oh, I hate those things. So actually maybe we should, we're going to have to agree to disagree there.
Fair enough. Awesome. Well, moving into some kind of rapid fire questions.
Okay.
So I'll ask the question and you don't have to answer in like one sentence, but just some rapid questions. Yeah. First would be like, what's a book, podcast, like piece of content that has really given you like a framework that's resonated with you personally or professionally?
Ooh, East of Eden by John Steinbeck.
Nice.
So East of Eden, it's big. It's a heavy book, but give it a read. It's all about the fact that people can change.
Right on.
That's it. I'm trying to
recommendation. That's pretty good.
Shoot. Okay. Yeah. Nice.
I like it. Second would be, what's your favorite AI model? Like, what's your daily driver?
My daily driver, I write a lot. So I love Claude. I think Claude does a really nice job of letting you select a style in particular and their UX for selecting that style and developing that style, even naming it. I have like op-ed Kev and law Kev as my different styles. And nice. So yeah, I can be pretty specific. Don't worry, to my wife, there is not a text wife style.
I have seen some interesting like MCP servers, like, hey, text my girlfriend like a date idea based on previous date ideas.
Oh gosh, yeah, that's called a divorce waiting to happen. But yeah.
Kind of corollary to the favorite model. What's your favorite AI tool or platform that you've used recently that you just think is super cool?
Oof. I mean, this is going to be really boring. I do think LexisNexis does a pretty good job of its AI tool of just,
Cool.
I think my AI research has improved because of its functionality, and it does what it's intended to do. It's nice and boring. And I think that boring AI is sometimes the best AI if I just want it to work well. And
For people that don't know LexisNexis, that's a database of case law, correct?
exactly. Yeah. And just the probably the leading tool of one of two leading tools that lawyers use to do their legal research and find good opinions and all that.
Interesting company because they also own a couple of conferences, like in-person conferences, and also scientific publishing journals.
Oh.
Really fascinating business.
Okay.
I don't remember exactly why I know that, but yeah.
Yeah,
LexisNexis
history's
is
mysteries. Okay.
Very
Yeah.
interesting company. It's owned by a company called Relix, RELX.
Oh, okay. I may need to do a
underneath that
deep
is
dive.
LexisNexis and other properties. This is my Jake mug. It's a
awesome.
prized possession. Thank you. I really like it. If you were to have a Kevin mug, what would be kind of like a few words or a phrase that would be on your mug?
Oh. I think the phrase would be create enduring ideas.
Nice.
So I am motivated by trying to change how people think about things. I think we are really path dependent and we get set in our ways of thinking this is the way it's been and so this is the way it should be. And sometimes that applies to even ignoring ways that have been, right? So like I think in some ways the best path forward is more traditionalist thinking that we've gotten away from. Like, what if we had stronger communities where we weren't just living in anonymous buildings and door dashing food? We can recreate those sorts of vibes and those sorts of strong communities, but we've just gotten so used to our lives in our little bubbles. So create enduring ideas because it's fun to push folks to consider new thoughts and new paradigms.
I dig it. I really like that. And then last question, what's your favorite nice restaurant in Austin so far?
Easy. Suerte.
Oh, good
Suerte.
one. Good pick.
Oh my god.
Brisket Suadero tacos.
Briskets.
Ooh.
Oh man, they have this mezcal drink. I want to say it's the Soraya.
Mm-hmm.
It is so dangerously good. I have one sip and I'm like, I should probably have 4 more. But that would be a bad night.
That's a great one.
Yeah.
On East 6th, my favorite story of Suerte is I went there for the first time with my family for like a family dinner. And we got the brisket suadero tacos. They were so good that instead of ordering dessert, we ordered more brisket suadero tacos. So we're like, these are so incredible.
They're so good. I've never, my wife's vegan like 90% of the time and vegetarian the other 10% of the time. Half the time I'm eating her stuff because it's so good. So the pro tip is take that burrito taco and ask for the mushroom version.
Oh, well, brisket suadero taco, but I bet that would.
No. So I'm saying you can ask for a mushroom version of that taco.
Oh, wow. Okay.
Don't knock it till you try it.
All right.
Yeah.
Good recommendation. I feel like everyone always leans towards like, oh, what's your favorite breakfast taco or queso or whatever, but we got a really good food scene. So I like
so
to
good.
hear what people
But
are
for
interested
breakfast
in.
tacos, Quickie Picky.
Okay.
Yeah, try it on
Right on.
11th.
All
Yeah.
right. Right on. Quickie Picky on 11th. I drive past there every day, so
There you
maybe
go.
I will someday.
Okay.
Cool. Well, that's all for the rapid fire questions. So just to quickly wrap up, like, want to hear what are you looking forward to or excited about over the next 6 to 12 months, kind of generally in AI policy world, specifically within your role at UT Law, kind of like what does the future look like for you and what are you excited about?
Yeah, I think I'm most jazzed about getting this AI innovation and law program started at UT. I mean, we are going to be the leading law school in preparing students to think about innovation policy and AI, and that's just awesome. I mean, if I can train 6, 12, 18 students to be the first wave of folks who are going into law offices, who are going into state legislatures, who are working with think tanks to spread new ideas, those enduring ideas about, hey, AI can be transformative. AI can unleash so many new potentials. how do we design policies and laws to achieve that? And there's so much low-hanging fruit right now. I mean, you can go follow the Center for Data Innovation. Every Monday, they've got a list of 10 awesome ways that AI is being used to do real good policy work. Today, for example, there was a use case of eyeglasses that also can serve as hearing aids.
Nice.
What? Like, it's just nuts. But now think about the kid who doesn't have to walk around with those funny looking hearing aids and not trying to knock it, but right? Like, they get stigmatized because of something that's wildly out of their control. Now they just get to pop on some eyeglasses. And finding ways to make those use cases of AI more prolific and just ease the acceleration of all these incredible AI innovations. That's what wakes me up in the morning and why I'm so excited to be here in Austin.
Nice. And you're doing your first class this fall, right?
This fall. So come and roll.
4 weeks away-ish, right?
Yeah, I guess I should probably write my syllabus. I'm just kidding. It's
AI
ready to
will
go.
do it for you.
Yeah, AI will do it for me. And, AI makes me change it every single week because there's just so much news coming out. But it's a heck of a lot of fun.
And so then you also host a podcast, Scaling Laws.
Scaling Laws.
And then you've got a book coming out? Is that right?
Not a book. Well, maybe. A few folks have nudged me. So maybe a book, but I maintain a Substack called Appleseed AI. That's all about spreading ideas and spreading innovative policy solutions.
So the last question is for anyone that wants to follow up with you, get involved with your work at UT or Appleseeds or listen to your podcast, what's the best way to follow your work and get involved?
I'd say follow me on X. It's just at Kevin T. Frazier, Frazier.
We'll put a link
All right, that's easier. Or Bluesky, I'm there too. Or LinkedIn. Kind of have to be everywhere these days.
Right on. Kevin, thank you so much.
Thank you,
awesome.
Jake. Yeah,
Appreciate
pleasure.
you coming on.
Oh, geez. All right. Have a good one.
We're going to make it work.
Yeah.
You too.